everyone, welcome to Canadian Fertility Consulting's webinar on why egg donor contracts make sense. We're very excited to be here today with fertility lawyer Cindy Wasser and CEO Leia Swanberg. I'm going to go over some quick housekeeping stuff before they take over. If you have any questions throughout the webinar, you can type them into the drop-down box questions that you'll find on the right-hand side of your screen. If you have any, you can type those questions to either privately to the presenters or for everyone to see. You can also type them into the chat box on the right-hand side of your screen. I will type in everyone's contact information into the chat box as well. So if you have any questions after the webinar, feel free to contact the presenters individually. You are all on mute currently, so just wait until the end and Cindy will ask for questions. And I hope you all enjoy the webinar, and I'll hand over to CEO Leia Swanberg.
Hi everyone, thank you so much for attending our webinar. If at any point you have to leave the webinar, please know that it will be recorded and we will be posting it on our YouTube channel for you to get the full length of the webinar. I do also just want to let you know that we'll be having these webinars once a week on various topics. So if there are any topics that you'd like to learn more about in the fertility world, we would be more than happy to find the expert to answer your questions. So just a bit of background. CFC, for those of you who aren't working with us and just on this webinar, and sort of learning about us for the first time, we offer a full service surrogacy program, and we also have a sister company, Egg Helpers, and we offer anonymous and known egg donors for intended parents around the world who are accessing fertility treatments in Canada or in the US. We also offer for many intended parents who may just have questions or want an agent to facilitate even a known donation. We often will refer people to fertility clinics or to legal professionals to ensure that they're with the best clinic that will provide them with, the highest level of care and service, and as well to legal professionals who will really be able to hammer out the details. And for us, it's not our job to decide what goes into a legal contract. It's our job to find you the expert that will find out from you what's important to have in your legal agreement, and to ensure that the donor you work with, whether it's your sister, cousin, friend, whether it's a donor through our program or someone else's, that donor also has the support that she needs, from the counselor to the clinic to a legal professional for her as well. So I'm going to pass it over to Cindy, who's going to walk you through why having a donor agreement matters, and give you just some insight into why, if you have worked with the donor or planning on working with the donor, why it may make sense for you to complete a donor agreement, whether you're moving into the process or whether the egg retrieval has already occurred. It's never too late to get great legal advice, and it's never too late to put a contract together. So I will pass that over to Cindy now.
Thank you, Leah. So, hello everybody. I'd like to introduce myself. It's Cindy Wasser, and I am the principal here at Hope Springs Fertility Law. We do nothing but fertility law in this firm, and I became a fertility lawyer after about 20 years practicing criminal defense law and having my own personal experience with both requiring an egg donor and a surrogate in order to make my family with my husband. So it was on the verge of having our surrogate finally pregnant that I started thinking about egg donor contracts. And for today's talk, I'm actually going to start by telling you why you don't need them and make you wait to the very end to give you the really important reasons for why you might consider having one. First of all, in Canada, there is no legal requirement that you have an egg donor contract before proceeding. there is no law in Canada that actually states that having a contract or that the contract itself would be enforced by any court. And in many provinces, and most recently in Ontario as of January, there is in fact legislation that states that a donor is not a parent just by virtue of the fact of being a donor. So there are significantly good legal protections in place by statute for those of you who require the assistance of a donor in terms of parental rights. Now, there are very good reasons for why you might consider having them. Number one, where there is legislation, it is silent with respect to the position of the donor's partner or spouse. So there is nothing stating that the donor spouse has no parental rights. And given that where there's legislation saying the donor doesn't have parental rights, there's a very good reason to believe neither would the spouse or partner. But in provinces where the legislation is silent, we just don't know what would happen if someday somewhere a spouse decided to litigate, or a donor where there is no statutory provision. Another reason why you might consider having one is that this is an agreement with respect to your rights with the donor only. And this is the only place where you interact with the donor directly, even if it's anonymous. So when it comes down to what her expenses are, whatever information you may have from an agency or clinic that you're dealing with directly may be very different from what rights you want to establish between you and your donor. A contract between you and your donor would define what types of expenses and how they will be paid. So mine always state that no expenses or reimbursements are paid to the donor unless she provides receipts or a statement of her expenses within a certain period of time, which is reasonable post-retrieval. And in my case, I use 45 days. It also states what happens if the donor backs down. If she started the injectable medication and decides for whatever reason that she is not going to pursue this, other than, of course, the doctor saying it's not working and we need to postpone or cancel. In the case where she decides on her own to walk away from it, then the contract, and mine do say this, states clearly that you will not be responsible for paying her expenses in that case. And so that's a pretty important safeguard for you. Another reason is related to the medical risks, the financial risks, the emotional risks associated with undergoing the retrieval for the donor. When a donor in Canada goes to a clinic, she is required, as the clinic is required by law, to have her sign a number of forms called consents. And the consents talk about understanding the medical risks and accepting those medical risks. Without seeing a lawyer, that very young woman is signing these very complicated documents. And although they may be called informed consents, I don't think it would take much for her sometime later to say, I really didn't appreciate what the risks were. I was only 21 or 22, and I didn't have a lawyer. So it's a very good insurance for the intended parent to know that on top of that, she's had the opportunity to sit down with a lawyer for likely a good hour talking about these issues. And then it is highly unlikely she'd be in a good position to say, I didn't appreciate what I was doing. Another really, really good reason to have a donor contract is the issue of confidentiality. Time and time again, my clients talk to me about the importance of keeping this quiet. They're not ready to discuss it with anybody. But there's no obligation on the donor to keep this confidential unless it's in a contract between the intended parent and the donor. And again, if the donor has a spouse or partner, we also want that spouse or partner to agree to confidentiality as well. So the contract is the only place where you will get that promise from them legally that they will not talk to anybody about their or her genetic link to your child. On the flip side of that, when your child has grown up a little bit and you're more comfortable with the conception and the creation of this child, there may come a time that you feel you wish to disclose to the child how he or she was created. And as the child grows up, he or she may have questions and may one day wish to have contact with your donor. And you should, as a parent, be able to decide when the appropriate time is for that contact. You'll be deciding so many things, why not that? So most anonymous donors go into this with an understanding that there will never be contact unless and until the child is 18. And that rule was always in place because of parental rights. The child at 18 would not likely be a concern for custody or child support issues. But now that the laws in provinces are developing and parental rights are no longer a concern, that age limit should not be the issue. It really should be when you as parents decide your child is of an appropriate age and level of maturity to understand the truth. And if contact is requested and you as parents feel it's important, it would be really wonderful if you could offer that to your child when the time comes. And so how do you do that without her agreement? At least now, if she sees the lawyer, they can talk about this issue. And she can agree, as is stated in my contracts, that when that request for contact is made, as of this time, she agrees to do so. And you'll be providing your child with a greater opportunity to understand his or her genetics. Another reason to consider the agreement, and in my opinion, likely the most important two reasons, are the mutual disclosure of gender and birth date of all offspring and future important medical information. Those of us who have needed donors to help us create a family cannot begin to describe the grief and the sadness and the sense of loss felt when we couldn't make our own babies. Those who require it because of sexual orientation understand that there's a political struggle, but all of us agree that we are grateful for the science that's given us this opportunity. But we must also think beyond ourselves about the creation of the child we are making and our role and responsibility as a parent. We are making children who have a biological connection to other people, and we don't know anything about those other people. We don't know where they are. And our children have a right to know who those people are if they want to one day. And so one day when your child grows up, before you know it, and they start developing romantic feelings for other people, there will also be a concern that there are potential half-siblings out there that should be off limits and they don't know where to find them or how to make those initial inquiries. Plus, they may just want to know that there are half-siblings out there. They may one day want to reach out to them, and our children should have that choice when we feel it's appropriate for them. So by offering mutual disclosure of gender and birth date, you find out all the other children who are out there, and you can warn your child as he or she grows up to at least stand back and make further inquiries of any child that matches the gender and birth date of a potential sibling. For future medical information, also very critical, your donor today will of course be extremely healthy. And those of you who do extensive genetic testing will also find out whether there are any likelihood markers of potential cancers. However, nothing is perfect, and the science only goes so far. If in 15 or 20 years from now, your donor unfortunately does contract a bad cancer, and it's a highly genetic cancer, you as a parent ought to be able to tell your child about it. Your child may be an adult and may wish to have known that information, But if you didn't have a contract with your donor, how would you know? And this is really what happened to me, is that shortly after our surrogate was pregnant, my own mother developed serious cancer. And I thought about the fact that I knew about it for my own protection, but how would I ever pass that information on to my children if their biological genetic link developed such a cancer? And so how do we get this information in an anonymous donation? And so now that I've outlined many good reasons for having the contract, I'd like to talk about the anonymous versus the known donation and how information passes through you and your donor in both situations. With an anonymous donation, which has always been the most common form, the agency or the clinic would have the information of the donor. And so the contracts would state that the required passing of information would either be through your clinic, your agency, or the lawyers. And it would depend on what type of information is required. So quite frequently, the lawyers and I will pass on information of the gender and birth date of a baby as we work with the donor or intended parents over the years, and we keep track of that information. A clinic would have the medical information and the identity of the donor, the provincial medical health insurance policy number to track the donor if any pertinent medical information was required of her or to be given to her. And an agency has all kinds of information about the donor and of the intended parents as well, so that information can be passed on through the agency. If you choose to have a known donor, then it's possible for you and the donor to agree to pass on that information to each other over the years. So a contract with a known donor will still state that although you know each other's identities, you wish to maintain a certain level of boundaries and privacy and respect your rights and your rights of privacy, so that you may continue to pass on this required information through your agency, your clinic, or your lawyers. But if you decide to actually correspond directly, then why not do it directly? If your donor at 22 is very healthy, but at 52 develops some very significant cancer, what is the chance of her thinking about notifying you or going back to the agency some 30 years ago where she donated? It's much stronger naturally if you are a real person to her. So if you choose a known donation, you become real. She knows your identity. And known donation occurs in a vast range of ways. They're simply sharing the information of names and addresses, all the way to becoming friends and close. But you would never have her develop a parental relationship with your child. Some people simply choose to text or email their donor once a year. Some never communicate with the donor, but have her identity so that it's more real. And that is a totally personal decision. There is no legal issue involved in the extent to which you become known if you choose it. So those are the variations between known and anonymous in donation and the way in which you would communicate important information, and an outline of the very important reasons for having a donor contract. It really is, in essence, the only way you guarantee this important information for your child. Should you decide not to have one, it's important to understand a couple of things. One, many clinics and agencies have personal business policies that dictate if the donor is anonymous, they want you to have a contract. Another issue is if it's a known donor, if it's anonymous, they may not require that of you. However, if your donor previously donated or intends to donate in the future to people who do have a contract, she may find herself obligated to obtain the medical information of your offspring and the gender and birth date of your children to pass on to those other families. Because it's not just her medical information, it's the offspring. And if for example, there are 3 different families that she helped create children for, one of those children may become ill, and it may be something that is genetically traced to the maternal donor, in which case you would need to know that information, I would think, as well, for the safety and protection of your child. And so the donor is obligated, if she's ever entered into a contract, to enter into another one with each donation, and you may not have a choice in selecting that particular donor. So I think I've covered all of the important reasons for having a donor contract, and I hope I've given you all something to think about. If you have any questions, this is a good time to start typing them, and then I'd be happy to answer. I think we have a few more minutes. So let's see if I can get the questions. Okay, I'm not sure that, I don't think that there are any questions at this time, or else I may not be seeing them. I'll give it another minute, and no, I don't see any questions. So if anybody does have any questions in the future after reviewing this, please feel free to contact me directly at Hope Springs Fertility Law. The webinar will also be posted on our Facebook page, LinkedIn, and website as well. We have a YouTube channel. So thank you very much to CFC and Egg Helpers for this opportunity, and I look forward to hearing from anybody and answering any questions that you have. Bye.